most of what we do is knowing what not to do, knowing when not to ask a question. And you get the outline prepared by AI and you just read the questions without thinking about it, which I think a lot of people are starting to do. That's problematic.
The worst thing that can happen to you is you put on your suit and you strip away your humanity. In this context, the AI should be an enhancement as opposed to a replacement of your humanity as a lawyer. The more you can focus on that, the more effective an advocate you're going to be in your profession, and you're going to be able to serve your clients in a way that maybe some others can't do.
Howdy, and welcome to the show. Cooper's Code focuses on legal issues and helps practitioners do the best they possibly can for their clients. This is the AI episode, where we have the wonderful opportunity to talk about AI issues with co-hosts Marshall Cole and Shahrad Milanfar. We've got some wonderful topics to dive into today, and rather than kind of dance around stuff, I think we should just head straight into it. As an aside, just to fill people in on some of how this show gets assembled, between the shows, we share ideas, and by we share ideas, I mean Shahrad, who is just diligent in terms of following the news, oftentimes goes through and picks stuff up, and we assemble it into our outline. I think every one of this episode are from Shahrad, so I would say dealer's choice. Shahrad, where do you want to start with topics today?
How about the federal judiciary's attempt to hide the judges' identities and then having the sleuths on the internet figure it out?
I love that. And before we go into it, let me just, as lawyers would say, lay foundation. This is the case involving the federal judge who was found to have been having unusual activity, we'll call it that, in chambers with someone who is not the federal judge's significant other. And this came before the disciplinary committee, and the disciplinary committee chose to try to keep the judge's name quiet. And with that, Shahrad, do you want to take it places?
Yeah, so basically the opinion that was published had the names, not included. But then as people read it, there was a footnote that referred to law clerks and the terms of those law clerks. So the sleuths went to work, and I believe they fed it into the AI, and the AI was able to limit it and actually zero in on the specific identities of the people that the writers had attempted to hide. So it's interesting because, it may have taken a lot longer for somebody to do this type of analysis on their own, but it's actually pretty amazing that they were able to use AI to essentially pull the curtain back from something that the court was attempting to keep very discreet.
On that front, Marshall, since your work sometimes involves legal mal, disciplinary proceedings, any takeaways from this that you found in terms of caution in representation, other things where somebody's identity may be at issue?
I think it's worth noting that I believe it was about 10 minutes is what it indicates that it took for this de-anonymization process to take place. And I think, each time we have these episodes, I always find it interesting that there's just a new wrinkle in the legal community that we have to deal with. I mean, oftentimes plaintiffs file as does, and that's for a legitimate reason to protect their safety from potential further harm. And if now there's a way that certain AI features can be used to find out the identity of people whose names legitimately should be protected, we can debate whether this was one of those reasons or not. I mean, perhaps not, just lack of embarrassment. But, it's a really important issue that we need to address and perhaps rethink, because normally, redaction is something that we as lawyers are very comfortable doing, right? Redacting privileged information, redacting names. It's commonplace in what we do. And if now we as lawyers have to worry about whether that's sufficient enough to protect the privilege or the identity of certain person or the communications, that presents a problem for us. I don't think any of us are doing anything wrong with redacting. That's the best thing we can do. But I think it is something that we need to be careful with if there's a big mass amount of data and someone can dump it into a particular AI platform and it can kind of decompose it and reverse engineer what that material that's redacted is. I think that's the issue that we need to focus on and how realistic it is. So that when I read it, that was what I was thinking.
I will confess I hadn't even thought about potentially using, and obviously you need to use one that was where you had a business association agreement where you were making sure that you complied with HIPAA requirements, but dumping in redacted material to not to undo a redaction, but to help intuit information. That seems like something that one could easily do.
We have to know how to use it defensively and offensively in all of our conversations. And sometimes we tend to focus more on defensive and sometimes we focus more on offensive. This is like both, right? This is a clear case of you've got to know how to protect against it. But on the flip side, not that you should use it to do anything inappropriate, because I don't necessarily think trying to uncover something that's privileged is appropriate. But if there is something that's redacted or omitted for no legitimate reason, then certainly this technology is there for the taking for you to potentially learn additional information you otherwise wouldn't be able to just connect those dots.
We have to remember that these systems are predictive models, right? When they originally came out, it's, hey, what's the chance that the next word is going to be X, Y, or Z? And that could be really useful if you have a redacted document to try to at least give you a better guess of what you're looking at. But the other piece of it is that what this did was basically acted as a private investigator, right? And was able to find information that may have been a lot harder to find if you're a human being doing all the steps. Now, I'll give you an example of something that happened to us just the other day. We got a defendant's document production, and they're saying that there's only X amount of insurance, there's no other policy, da-da-da-da. And when the documents were analyzed by our AI system, it flagged that there were two different insurance policy numbers that it found. Well, the guy at the scene of the crash, where he gave the cops his insurance information, he gave a different set of policy numbers than the ones that we have. So automatically, that allows us to do the due diligence. Now, we probably would have caught that at some point, but the fact that he was able to catch it within minutes of the information being entered into the system was something that, would allow us to immediately confer and say, hey, wait a minute, how come there are two policies? Have you done a search for this one?
Fascinating. I was smiling at the beginning of your response because in terms of being predictive models, I'm seeing somebody who does this exercise. It turns into redaction Mad Libs. In terms of putting words into the document that may or may not be the right words.
Right. Well, it's almost like a improvisational acting class, right?
Yeah.
I say a word and then you say another word, and who knows what the next word is going to be.
Yeah. The next section, and there, we have 3 different situations where OpenAI is being sued. And my personal favorite, and I think we should start with Florida. And Shahrad, before we start, you had a comment about if somebody's going to get sued in Florida, there's an indication there.
Well, not only is getting sued in Florida, but getting sued in Florida by the Florida Attorney General. You'd usually think, okay, well, if it's one of the more liberal states where something like this would be happening, but if it's happening in Florida, you really have to look at what would cause that state to come after you. And I thought that was an interesting piece of it because they not only sued, I believe, OpenAI, they actually sued Sam Altman personally as well.
When you sent this article over, it made me think of my long ago, I'm dating myself. I don't know if the two of you remember Love Lines back in the day with Dr. Drew and Adam Carolla. One of the side games they would play was they would read an article and you had to guess whether the outlandish activity had happened in Florida or Germany. The game was called Florida or Germany. And so when I saw this of getting sued in Florida by Florida, all I could think of was that game. I think we buried the lead though. What was it that OpenAI and Sam Altman were personally getting sued for?
it basically says that OpenAI their conduct is attributable to a web of deceit and the exploitation of users, leveraging their data and safety to boost OpenAI's market value at unacceptable costs. So basically they want to hold him personally responsible because I guess they're alleging that this is reckless and willful conduct by the company, that he's doing things that are specifically harming Florida residents, and the attorney general is stepping in to essentially put a stop to it. And a lot of it has to do with the addiction and cognitive decline, suicide, violence, and related harms that are occurring. And I think we know that there was at least one incident that occurred that the young man had been consulting ChatGPT before he went out and tried to kill a bunch of people.
The parallels here with the social media trials are really interesting on that front.
Yeah, and as we know that both the Lanier firm and the Panish firm obtained a verdict down in LA, and there was the New Mexico verdict that came in pretty strong as well. And I've not heard in terms of what's going on, post trial, but I suspect that these companies are finally understanding that they're going to have to give up some of their profits, considering how they went about earning them.
Makes me wonder, because I'm always curious about coverage, because oftentimes there's insurance coverage before you're dealing with personal money for some of this stuff. And does OpenAI have a product policy? What's its? I presume the software is a product.
I'm sure they're going to argue that it is not, right? But that's interesting, because if you argue from a litigation standpoint that it's not a product, therefore we're not held liable under product liability law, and then you turn around and you try to tell your insurance company, hey, this is a product, pay us or pay the claim, that's going to be a very interesting tightrope to walk for them.
Marshall, I'm trying to tee this up. I always think of you as a legal mal and lawyers behaving badly guy. There's a business owner who is suing OpenAI for providing faulty legal advice. Just curious about your thoughts on this.
First of all, I'm way more complex of an individual than just that, but I don't really appreciate being silent. But in any event, I laughed at this article for a couple of reasons. I just think it's a business owner suing OpenAI for giving the owner faulty advice regarding confidentiality agreements and various contracts that she was sending out. But the part that I found most interesting was that the allegations in the complaint plead that she was, and I want to just get it right, she was interacting with the AI assistant from midnight to 5 a.m., where she questioned the AI assistant's truthfulness and asked it to provide only accurate information. She then asked the chatbot to sign contracts stating it would tell the truth and would not disclose confidential information. The chatbot responded with what it represented as an e-signature that it claimed was binding under the Electronic Signatures and Global and National Commerce Act of 2000. I've never heard of that act, but I can't wait to cite it at some point in time. I think some of these, it's like, I don't know what business this person owned, but, there is going to be, and I do think it will apply to more sophisticated users, an assumption of risk. Okay. If you're a business owner and you're doing these types of things and previously, were using your own confidentiality agreements or hiring a law firm, I'm pretty sure OpenAI early on created a prompt or a disclaimer that said, we aren't a lawyer. We are not providing you legal advice. I have a feeling you had to have been there when this person was doing that, but I don't want to speculate. But I don't view this as the same as the horrible circumstances regarding suicide or a lay person just seeking regular everyday advice. We've seen lay people use it for legal advice, and courts hammer them on that it's not privileged and that everything that's learned is going to be discoverable. But I just think this is a little bit different. I'm curious how much publicity it'll get going forward. And I do think there is somewhat of an assumption of a risk based on your education level.
One of the things that I wondered about in terms of how this is going to unfold, because we're in, I think, sort of novel areas of law. If you have a agent in a conversation where the agent makes commitments that are different than the agreement that you signed to use ChatGPT, for example, let's say that there truly is a global signature act of 2000, and that this agent agreed to be bound by it with an e-signature. Does the agent have authority to bind the company beyond the agreement that you initially signed to use the software, or is that a hallucination? It raises interesting questions.
It sure does. And I think maybe we talked about this a while ago with hearsay, right? And how hearsay requires there to be a declarant, and there's been a determination by a court that these statements aren't being made by a declarant, so there's no hearsay problem. I think, what's required to enter into a contract? Can something that's not a person enter into a contract that binds the company, or has any impact? I agree with you completely. These are all new issues. I think even the redaction issue, right? These are all new issues that I find to be fascinating, that are going to come up more and more as people try new and different things with the various products.
They're essentially approaching super intelligence, right? So the idea that this thing was smarter than me, how can I be held responsible for what it told me to do, right, is going to be an issue. But the other thing I thought about as you were talking, Marshall, was that if the system initially gives a disclaimer, hey, I'm not a lawyer, da 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 da, and then as you're going through that chat, eventually it gives you a signature and says this is binding, what are you going to believe? And how's that going to play out in the long run? And to me, if the AI systems were, or the designers of these AI systems were smart, that disclaimer would always be at the end, regardless of what it tells you. And I think they've started to do that to a certain extent, but I don't know if it's that far-fetched for somebody at 4 a.m. to think, yeah, it told me it was real. It gave me a signature that it was real.
Well, it's funny. So I just looked it up for our benefit here. So that the Electronic Signatures and Global and National Commerce Act, which was passed in 2000, is a federal law ensuring that electronic contracts and signatures are legally binding. So that's certainly confusing for someone. We I don't think any of the three of us were familiar with it, but easy for AI to cite that and say, oh yeah, this signature that this non-existent person created is legally binding. Certainly confusing and interesting that it would do what it did, but
there is a similar law in California that applies as well, right? So, and again, it makes it sound very official. That's, I think, the issue with it, right? It's saying this is something that actually exists. And if the person were to leave, let's say, ChatGPT and go to Google and punch it in, they would find something that would essentially create confirmation bias for them. So it is an interesting onion to unpeel, because I think there's equally valid points and counterpoints on each side.
But to your point, Shahrad, I think it also, and we've discussed this a lot, the more you say, tell me the truth, only do it right? It's the golden retriever that Miles always talks about. And it's just such a perfect example of it playing out horribly for the person who's using it, by just telling it what you want. And it's just saying, oh yeah, I'll do that. And I'm actually even going to get you some really good evidence to show you that I'm doing it and trick you.
Well, as we round out the trifecta of OpenAI cases, we got Florida, we got business owner, and let's piss off $1 trillion company. We got Apple suing OpenAI. Shahrad, do you want to take us through this one?
Sure. Basically, Apple sued OpenAI in federal court here in the Bay Area, alleging that former Apple employees, so basically Johnny Ives Group left Apple, started their own company, and then they were acquired by OpenAI, and that brought 55 employees into OpenAI, and a lot of those high-level executives were former Apple executives. the allegations are that in job interviews and in other contexts, OpenAI has been essentially obtaining confidential and trade secret information from Apple employees and former Apple employees by essentially like coaching people they're interviewing to provide information or to get information and then go to Apple manufacturing partners and suppliers and say, hey, show us how Apple does this. And I'm assuming that they're attempting to create their own product, like some sort of a, super intelligent phone or something like that. But apparently Apple got wind of it. They sent them a letter in, I believe, February and eventually filed a lawsuit. I believe it was either last month or earlier this month.
That should be very interesting to watch unfold. As you noted before we started, Apple and OpenAI have a close relationship as it relates to Apple's use of OpenAI for some of its own work within its platforms.
They do, and I think Apple also invests to a certain extent in Anthropic as well. So I don't know how that's going to play out in the big picture. But if you have OpenAI's ChatGPT baked into a lot of the cell phone and laptop and computer technology that Apple is putting out, this could be a pretty significant issue for the companies to battle out in court.
Almost a Trojan horse, I believe you said before we started.
That's right. That's right.
And the only reason I'm throwing that up there is I'm trying to lay the groundwork for our Odyssey reference as a nod to Chris Nolan in the show. Shahrad, you also noted something related to University of Chicago and their position on AI and technology.
Yes. So University of Chicago Law School got a lot of press recently because the news reports indicated that they're banning all technology basically for first-year law students. Well, I looked at their AI strategy statement, and it's a little bit more nuanced than that. Basically, the thrust of it is we need to teach these young lawyers how to learn and how to research and how to write on their own, and then they can go out and do the internships and do other things in order to enhance their abilities and to become more complete lawyers, which is not an unreasonable expectation. I think we've talked about that on this show, is how do you set yourself up as a young lawyer to be an asset to your firm and to provide quality services without just doing shortcuts and then going to essentially have atrophy of your brain because you can't think for yourself. So those are all valid concerns that the law schools are now flagging. And there is a lot of outrage, but at the same time, I think the goal of creating more complete lawyers who are better prepared to function in our profession is a good one. Now, if they could only add to that as, with training to help them deal with the stress of the profession, I think that would be a great addition.
And I think one interesting piece that they focused on, which I really liked, was the parts of our job that they feel, and I agree with, will remain inherently human, that being oral advocacy, strategic judgment, and client relationships. And of course, we can use AI behind all of those things. But at the end of the day, at least for now, we all have to get up and make oral arguments. And if you just use AI to prepare your whole outline and you just parrot what it says, I don't think your argument is going to be as effective as someone who's a true advocate for their client and understands the nuances that go into things, how to read the judge, how to read the jury throughout the argument or whatever they're doing. Same thing, strategic judgment. Most of what we do is knowing what not to do, knowing when not to ask a question. And you get the outline prepared by AI and you just read the questions without thinking about it, which I think a lot of people are starting to do. That's problematic. And then lastly, obviously, client relationships. I think, you've got to be that person that fits with your personality, that lives in your own skin, that takes years to figure out how to get clients. I think we've all tried other approaches that didn't work for us throughout our career in trying to get business. And unless you know how to do that on your own and learn the hard way of just trying to do it and failing and then failing again, it becomes hard. And I really appreciate it that they put an emphasis on that aspect, because I think if they really do pay attention to that, it would be really important and really beneficial to their students by focusing on it. I like that part here.
You make a great point. One of the things I've always told younger lawyers when I teach trial advocacy and trial skills or whatever is the worst thing that can happen to you is you put on your suit and you strip away your humanity. Right? So in this context, the AI should be an enhancement as opposed to a replacement of your humanity as a lawyer, whether it's interacting with a client, reading a brief and saying, if I was a judge with 10 motions on my calendar or a research attorney, would I really want to read this, 20-page repetitive thing that's in front of me? Those are all things that we bring to the table as human beings. And I think the takeaway for me is the more you can focus on that, the more effective an advocate you're going to be in your profession, and you're going to be able to serve your clients in a way that maybe some others can't do.
I don't even think you have to have AI with the judge. I mean, we all Zoom post-COVID replaced court hearings by and large. But if you go in person for that important hearing or any of the hearings, you are going to get that human connection. You're going to get, generally speaking, the appreciation from the court that actually a living human being is in there, because it's so rare now to see a full gallery of lawyers. I don't ever see it, but so that's the human connection that has been lost, and it's only getting further lost through the use of AI, just because you're not even getting the interpersonal connection, just like the lack of just actual connection.
Well, this actually happened to us in a pretty significant elder abuse case that we're handling. We had a motion for summary judgment brought by the defense. Me and my colleague went to the courthouse, which is literally 20 minutes from our office. The other attorney's office is in the same town, and they opted to appear by Zoom. And I was like scratching my head, because I thought, when I did defense work, if you showed up on Zoom when the other side shows up in person, the client would be livid. And the irony was that the owner of the facility was actually there in the courthouse and opted not to come in because his own lawyers weren't there. So it's amazing to me how that has been adopted as the norm versus, put your suit on and go in the courthouse. And even if it's a 10-minute hearing, that might be a rep that you're not getting otherwise.
Just for the sake of argument, Shahrad, I'll argue the contrary position, because I've heard some variants of this more in deposition than oral argument. But the notion that when you're on Zoom and you have your 3 monitors and you have links and everything else, when the court asks a very precise question on something that perhaps you weren't 100% on the ability to click on it and say, yes, I see that footnote that you're referencing in Smith v. James A. And it's distinguishable because of blank, blank, and blank. I have heard lawyers who say, I really prefer to use the technology platform for deposition and the hearing because I have so much more at my fingertips.
While that is a point, in my opinion, I have an iPad and I can put my entire file on that iPad in a matter of 5 minutes. So the idea that you have more access, to me, this is something where the screen is being used as a shield or a blanket for your own safety, as opposed to putting yourself out there and having a judge look you in the eye and ask you tough questions in person. So to me, being in the courtroom is pushing you out of your comfort zone. And if you're going to call yourself a trial lawyer and say, I'm going to try cases, you have to condition yourself to try to make appearances in person as much as possible. Granted, it's not always possible, but a motion for summary judgment, that's a pretty important thing. And if possible, if it's 20 minutes from your office, you should show up.
To your point, Miles, I get that people like having everything right in front of them, the ability to access it. Query whether that person is as prepared as they would be if they actually had to be in court. Because generally speaking, everything that's going to come up should be in your papers. And I get it. Sometimes that's this thick and that's a lot of reading. But if I'm in court and I've never had a judge, if they ask me a question that I don't know the answer to right away, if I take my time to pull it out of the moving papers or wherever it is, and put it right in front of the court, that's always going to be accommodated as I turn through the pages. And likewise, to Shahrad's point, now I have my laptop there. If I do need to look up something that isn't there, it's easily accessible, and the court's going to be patient with you. So, and also I think it's a check and a balance of like, I get it. Maybe that person likes having the access and the screen and the ability to have all that, but is that worth it over what you're losing with the just being there in person and seeing the judge's nuances and kind of nods? Because I've gotten them when the opposing counsel hasn't been in the courtroom, and maybe it's like, Marshall, stop, I got you. And you just don't get that. So query whether which is more beneficial, even for the person who finds it to be beneficial to be out of the court.
Well, and I think that both of you are likely right on lawyers not having the same granularity on their cases when they're appearing via Zoom. They're using the information, the accessibility as a crutch. And further on that, even in person, the number of times I've been in Law in Motion recently where I've seen lawyers acknowledge that they don't know the answer to questions in front of the court has been interesting. And let me define that a little bit more precisely. It's not unusual for the court to ask a penetrating question about a case, and you may not know that precise thing. But the number of times I've seen lawyers, and typically younger lawyers, just not know the answers to some of the basic tenets of their arguments makes me again wonder how much they're relying on technology so that they don't have that granularity. It's all the things that we're talking about where you haven't mastered it in terms of how you're presenting in the court, and those people just feeling more comfortable relying on technology rather than physical presence.
At the risk of sounding like an old guy, advocating for something in a certain way, the reality to me is that as human beings, we have to be able to assess each situation and make good decisions. And in a case where there's a summary judgment, and if you lose it and it's going to be a big deal, to me, it bears the weight of coming and actually looking the judge in the face so that that decision can be made in person. But maybe this lawyer had some brilliant thing up on the screen that allowed him to be more effective than he would have, and that was his decision. Again, from my perspective, we had two advocates arguing this on our side, and he was in his office arguing it in Zoom, where we basically had the same distance to travel to the courthouse. And if my lawyers had done that, I would be asking questions as to why that happened the way it did.
Any other AI technology things? I know we had one other outlier piece that we were considering touching on that was not AI, but anything else that we should cover on the tech front?
I just wanted to highlight, I mentioned it offline, sort of realistically what's happening to me in a few cases is that I can tell, particularly in relation to discovery, that I'm getting meet and confer letters that are generated by AI. And I guess I don't know for sure, but the reason that I feel that way, I have a strong feeling, is the pace at which I'm getting them from the time in which I serve my responses is very, very quick. And it's one firm in particular that's doing it on a few matters, and also same with motions to compel. And, we're drafting the responses to the meet and confer letter in human time. But I wonder, if we were to just have AI and draft the responses, you just have AI, doing meet and confer, it's going to be this interesting thing that gets created, which, discovery's always been, I think, an interesting issue between plaintiffs and defendants in litigation. Both sides claiming the other side uses it and uses it improperly and all of that. But when you have now just AI doing it for you, nobody's going to care anymore because it's not taking anyone the amount of time it used to take to, slave over the responses. Then this 10 to 15 page need confer letter, I think discovery is going to have to be revisited as we get more implementation of AI on a regular basis that isn't hallucinating, right? It's using it appropriately. It's citing the right code sections. It's using the, fine case law on generic issues that aren't going to be hallucinating on. It's just the pace. And so if we were to do it in response and respond the next day, and then you have a motion to compel drafted by AI, which it can do very well without the worry of hallucinating, what are we really doing? And we could maybe go to more of just a federal system where we just turn everything over to avoid the need of this back and forth, especially when it's not really burdening anyone on either side. So
Marshall.
That sounds interesting what's happening.
I said, oh, Marshall, you're singing music to my ears. I have always found the discovery process to be a tedious chore. And a tedious chore because on the contingent fee side, it benefits the hourly rate lawyer. And usually we turn all of our stuff over because, we've got to prove our case. So we need the other side to see the records and what happened to our people and everything else. And then it's this pulling teeth and fighting and scrapping. A federal system where people just turn shit over. Oh my God, that would be awesome. I don't think it's going to happen.
I'm facing more motions to compel than I feel like I've ever faced. I'm on the defense side, obviously, and in the vast majority of these, but most of our cases, it's the client file. We turn it over. There's nothing really left. People are bickering over the objections that we assert and requesting, demanding that they would move them. And I don't know if there's sort of a movement on the plaintiff side to have that occur, but, it's just kind of an interesting thing I'm seeing, and it doesn't have to do with AI, but I don't know if there's a trend, if it's a trend or just maybe we're really mean and don't we should be different. But I don't think so, because it's like, it's new. This is like within the last 6 to 8 months, all of a sudden it's like, man, we're getting a lot of motions to compel. We haven't done anything different. Yeah, and it's just a new thing we're seeing. Maybe it's because the plaintiffs firms are having, as typical plaintiffs firms that just go on doing work. They just, have AI draft motions to compel.
Yeah, the objection thing is interesting because, sometimes you'll see trends in like years ago, there was a trend on anytime you served a 998 formal offer to compromise, at a certain point, we just started getting these objections, which there's no such thing and never heard of them before, but the defense started serving them left and right. And so obviously there was some sort of a legal education or, it's filtered through. I haven't heard the same thing about people being upset about objections on the plaintiff side, but, maybe I'm not going to the right places.
Yeah, because sometimes we assert the objections, and then of course they notwithstanding the foregoing objections, here's all the documents or whatever it is. They're giving us grief over the fact that we can't assert the objections, or also, the preliminary statement that we sometimes include objections. I think there's some case that says that's improper, and so they're moving to compel to get that removed, which I feel like there's a CLE somewhere out there where people were told you should do this.
Yeah. Interesting. These are lawyers who apparently have more time on their hands than I do. Well, I think in light of the time, I'm going to pass over the sanction order that was not technology related, but interesting, and maybe we'll hit it on the next round. So, always a pleasure. I always feel like I've learned a lot more about the approach to technology in the law. So, really appreciate.
Thanks.
Always.
And thank you for listening. If you liked what you heard, please consider leaving us a 5-star review on your podcast platform of choice, and consider sharing this with a friend. If you have anything you'd like to share or anything you'd like us to cover, please email us at podcast@kupers.law. To all of you doing justice out there, happy hunting.